day we can meet before turnaround is meeting minutes. So the meeting minutes from February 5th through February 8th have been submitted for review and approval. I think we submitted those via email to committee. No, we put them in your folders February 13th. So if you could all pull out the draft meeting minutes from February 5th through February 8th, and I'll entertain discussion or a motion. Senator Gossage.
Madam Chair, I move we approve the minutes.
Is there a second? Oh, Senator Wilborn with the second. Thank you. Committee, you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, same sign. The motion carries. Thank you. And now we turn to final action on bills previously heard. And the first bill we are going to work this morning is Senate Bill 500. And Senate Bill 500 provides restricted driving privileges for certain individuals that fail to comply with a citation, authorizing certain individuals with revoked driver's licenses to be eligible for restricted driving privileges, and permitting such individuals to drive to and from dropping off or picking up children from school or childcare. So with that, a brief from the revisor when he's ready. Thank you. We realize that it's a busy time for staff as we approach turnaround, and that means each chamber of the legislature is working on passing out of their own chamber the bills that have originated in that chamber. So it's a busy time for staff as well as legislators. So when you're ready, thank you, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson, Office of Revisor Statutes. So as you mentioned, Senate Bill 500 is about driving privileges. Specifically, we're in KSA 8-2110. That's the statute dealing with failure to comply with a traffic citation. I'll just briefly say that current law requires you to pay in full your fines and court costs, and one of the big changes in the bill is to just require substantial compliance with those fines and court costs in making your payments. The other big thing is adding another place that you can drive while you're on a restricted driving privilege under this section. And that is being able to drive to and from dropping off or picking up children from school or childcare. And there's probably a couple other things in here, but those might be in amendments. So I'll just stop there and answer any questions.
Thank you. Committee, questions for the revisor? Not seeing any. Then is there discussion on the bill? Senator Wilborn.
Thank you, Madam Chair. I've been working with the Law Enforcement Kansas Chamber and the Justice Action Network, and also have kind of kept Mike Funkert in the loop. We're having a few amendments to offer. The first one I would like to offer is the one on court orders and violation exclusions, which are exclusions to the law as it relates to traffic violations. And I'll let the revisor explain the amendment in more detail. And by the way, I do have copies here to share with the committee as it relates to what statutes would be eliminated. They're the ones that are in color. What's it? Okay. The blue and green are the ones that would be excluded from coming under the violation section. And our revisor will explain that towards the end of all the different statutes that it touches. For example, and you can see the ones that are marked out in that highlight, green and blue, would no longer be considered a traffic violation per se.
That's in the green and blue?
Yes, green and blue.
Thank you. And we'll then wait for an explanation from the revisor of the amendment, or would you like to do that, Senator?
I would prefer that the revisor give the explanation. Thank you.
Thank you again, Madam Chair. Jason Thompson, one more time. So the easiest way to explain this might be to start on page 3. So you've got, in lieu of your suspension for failure to pay or failure to appear, you may submit to the Division of Vehicles a written request for restricted driving privileges, and you can apply and be eligible for those. If you have previously been, you may apply and be eligible if you've been previously approved. So you can do this more than once, I guess. And then this C is not inserted in the right place. I apologize. Collaboration between revisers here, and we were working a little quickly. So subsection cap B is the one that provides if you've been revoked solely for driving a motor vehicle at a time when your privilege to do so was canceled, suspended, or revoked for failure to comply with a traffic citation under this section, you can submit a written request for restricted driving privileges. And you qualify for those privileges with the restrictions provided in this subsection. And then there are some exclusions. One of the exclusions has to do with what offenses you have in your driving record. This provision is talking about violations of the listed sections or similar sections under city ordinance would not provide the basis for a violation of this section. So a failure to pay, essentially. And then the list is related to the list you were given with all of the subsection or all the sections of law that could have been listed. But this is the chosen list, as the vice chairperson indicated. And then I'm looking to page 1, where it's talking about when you fail to comply with the traffic citation, except for the violations provided in that new box, which is labeled subparagraph C. So I'll clean that up and make sure it points to the right place, but it's that box. So except for those violations that we just talked about, the district or municipal court mails notice that you're going to be suspended. And then the similar change on page 2, unless you've determined that the individual shall fulfill requirements set forth by the court, failure to abide results in them, the court, notifying the division that you'll be suspended for the failure to comply with the traffic citation. So essentially, the first piece refers to the box on page 3, and then there's some extra changes on page 4 about substantially complying, which is kind of cleanup related to the issue we talked about in brief. And then the final thing in this balloon is on the final page. There's a provision that says any order that restricts or suspends your driving privileges that is issued by the court has to have these 4 things. It has to identify what constitutes substantial compliance, specify what constitutes a later missed payment, consider waiver, reduction of fees, etc., and consider alternative requirements such as treatment or drug or alcohol treatment in lieu of restriction or suspension. So it's kind of a 2-prong amendment.
Thank you, Mr. Thompson. Are there any questions?
Are there questions for the revisor? I have one. The highlighted statutes in the list that is the box, capital C of the amendment, those list of statutes. There are other penalties in law if you violate those statutes, correct? Not just related to your driver's license, but there are other consequences for, we're not taking away all the consequences is my question.
Yes, thank you, Madam Chair. Jason Thompson again. So these are offenses under the I'm blanking on the name, Uniform Traffic Code or something to that effect in Chapter 8 that we're dealing with here. But specifically, these are offenses in the Uniform Fine Schedule. So you are issued a traffic citation, you are fined, you pay a ticket. And what the bill or what the amendment is attempting to do is say that in addition to those penalties that might be out there, failing to comply with the citation causes certain license consequences under 8-2110. But this amendment would say failure to comply with a traffic citation, except for these specific ones we have called out in that box, leads to suspension or revocation of your license. So,
But not these highlighted ones.
right. So essentially, you're still punished with a traffic citation and an associated fine, but it does not trigger an action on your license under 8-2110. It might trigger it in some other way. So I don't want to say there's no action on your license, but it doesn't trigger a failure to comply under this
And then
section.
And when I'm referring to the highlights on the document, I'm referring to the Chapter 8 statutes referenced in capital C of the amendment that we're on. Just for clarity for those following along. Are there other questions for the revisor? Senator Steffen.
Thank you. Let's look at page 4 of the bill, starting in line 13, kind of down through that amended area there. What's the what happens here? We're striking out the year period of time. So does this restricted license, this amendment leave it open-ended in perpetuity to be on a restricted license?
Is that a question for Senator Wilborn to answer or the revisor? Which
Well, I think the revisor can answer that because it's more, what's the takeaway from the changes in the bill there? It looks to me like that person can drive on a rescinded license for perpetuity. And I guess from there it'd be for the carrier of the amendment, it'd be why delete the year?
And I think maybe what you're looking at on page 4 has to do with some of the balloons in this amendment that has multiple balloons. But I'll let the revisor answer.
Thank you, Madam Chair. Jason Thompson again. So the senator is correct. It does strike some language on page 4 in subsection B. Gotta go down the list here. B2 capital D is the subsection we're looking at there on page 4. And essentially, my understanding is this is cleaning up that language so that it is dealing with the substantial compliance issue. The 1-year period is provided by was provided for certain restrictions under this section, but for violations of this section and the license that's granted essentially there was a 1-year requirement and it referenced that 1-year requirement, but that requirement has been replaced by 2 things. 1, substantial compliance, which is reflected in the balloon, and 2, the restrictions on page 3 that begin down in lines 31 through 34. So you're actually restricted for this license, this particular one, for either the period of time that you were revoked or 3 years from the date when the privileges were approved. So you've got a couple of timeframes provided elsewhere and you're trying to just talk about substantial compliance here because that's the new standard. So, long way of saying, yes, it is a little more open-ended, but no, it is not unlimited.
Yes, Senator Baumgartner.
Thank you, Madam Chair. So do we have a definition for substantial? Is it 51%?
Mr. Thompson?
Thank you, Madam Chair. The bill defines substantial compliance on page 6 in line 4, and it is just following the orders of the court involving payment of fines, costs, and penalties, and has not failed substantially in making payments or satisfying the terms of the court order. So it looks like it is very much for the court to determine whether you have complied substantially or not.
Okay, so for the carrier of the amendment, it's your understanding that the interpretation of substantial will be different, could likely be different in every municipality as far as how substantial or substantially is being construed. Is that correct?
Madam Chair, my response would be, and I do not intend to be flippant about that, but unfortunately that is kind of the case as it stands today. It's my understanding. And I might add, while I do have the microphone, Madam Chairman, that these recommendations were recommended in the interim committee on these crimes.
Thank you. I'll ask the revisor for some clarification on what a court would do with the term substantial compliance. Is it a matter of law, which I believe it is, for the trier of fact to determine what substantial compliance means?
Madam Chair, Jason Thompson again. So in these cases, you're talking about a court order and compliance with the court order. So the court is the sole determiner. There's no jury. There's no
Right, as the trier of fact, the
right.
court would determine, have you substantially complied or not?
It would be whether, just like any other sort of order of the court, did you comply with discovery or not? Did you comply with a warrant to appear or not?
Right.
Did you substantially comply or not?
All right, thank you. Senator Baumgartner, further questions, or does that answer your question?
It answers my question. It doesn't solve the concern that I have for the inconsistency. Part of our testimony that we received from Mr. Klump was that, he knew of particular courts that they worked with the individual and after a certain amount would dismiss the remaining balance. And the inconsistency, I think, will be difficult throughout the state. Thank you, Madam Chair.
Thank you. Committee, other discussion on the amendment? Senator Wilborn.
Thank you, and I appreciate Senator Baumgartner's comments, and that is an issue, of course. Mr. Klump did approve the substantial compliance language in this case. I just want to make that point.
Thank you. Committee, further discussion on the amendment? Senator Gossage.
Madam Chair, on page 6, it's my understanding that the court will determine what constitutes substantial. Is that correct?
That is. Yes.
Go ahead.
Oh, yes, Senator Wilborn.
Mr. Thompson, would you specifically answer that question? Yeah, it's the one we just talked about.
Yes, substantial compliance.
Sure. Madam Chair, just to reiterate, page 6 of the bill, that final provision that's new, subsection G, that would become subsection H in the amendment. It just says substantial compliance is what the court determines. So it would be up to the court to decide whether you've met that definition or not.
All right, thank you. Just wanted the clarification. Thank you, Madam Chair.
Thank you. Senator Baumgartner.
Thank you, Madam Chair. I appreciate the senator's question. The point I was trying to make is the courts will determine that, but that means every municipal and every county court can determine it however they want to. And you might not even have consistencies within the same region. Thank you, Madam Chair.
Thank you. Any further discussion on this part of the amendment? I'm not seeing any. Senator Wilborn, are there further balloons in this amendment to be considered, or is this the substance of the current amendment we're on?
This is the substance as explained by Mr. Thompson. Yes.
Okay, and did we get a second on the amendment? Second from Senator Olson. You all have heard the motion, and any further discussion on the motion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye. All those opposed, same sign. Okay, the motion carries, and we are back on the bill. Yes, Senator Baumgartner.
Thank you, Madam Chair. I have an amendment. Thank you. Yep. That's exactly where, yeah.
Senator Baumgartner, would you like to explain your amendment or have the reviser?
I'm happy to explain my amendment. I believe this is a common sense amendment, and I appreciate that the senator sitting next to me, Senator Bowers, who also served on this special committee, recognized that it's very similar language to what is allowed our teens that have their farm permit. So it is a common sense whereby they would have restricted driving privileges, and we would add to and from purchasing groceries or fuel and to or from religious worship services. And that is in the title as well as on pages 2 and 4. I'll stand for questions.
Thank you. Committee, any questions regarding the amendment? Yes, Senator Wilborn.
My comment is just simply this appears to be a common sense, just like the senator said. It's a friendly amendment.
Thank you. Any further discussion, or is there a second on the amendment? Second from Senator Bowers. Thank you. Committee, then, you all have heard the motion. All those in favor signify by saying aye.
Aye.
All those opposed, no. The motion carries. We are back on the bill. Senator Wilborn.
Madam Chair, I do have an amendment. I'll ask Mr. Thompson to hand it. It has to do with a 5-year amendment. Right. This is,
Hold on. Where's the balloon? Jason, where's the balloon?
no. Here. That's the way we like to get them through.
Just read it.
We can. She got one. Okay.
Committee, while we're waiting for that particular amendment, I think Senator Baumgardner has another proposed amendment. Senator?
Thank you, Madam Chair. And Madam Chair, I'm happy to have the reviser explain.
Thank you. Mr. Thompson?
Thank you, Madam Chair. So, Jason Thompson again. This is, as the title explained, or the amendment to the title explains, this would revoke the authority to suspend a person's driving privileges or license due to non-payment of fines or court costs, and provide for retroactive application of this new rule. There's a small change on page 4 that is sort of a cleanup amendment related to what you'll see in a minute, but just to say that if your license expired during the period that you were suspended for failure to comply with a traffic citation pursuant to subsection B, rather than what it says now. So just kind of a cleanup amendment related to the substance, which is the final page. This would add a new subsection that provides a person's privileges or license shall not be suspended due to non-payment of fines or court costs associated with a traffic citation. And this would apply retroactively to a person whose license was suspended prior to July 1st of 2024 due to non-payment of fines or court costs associated with a traffic citation. And the peanut of this is, if you look back to page 1 and the strike that I didn't mention down there in lines 28 through 30, essentially when you're not complying now, you would only be failing to appear or failing to pay fines and court costs as imposed by a court order. You would only be suspended. Your license would only be suspended for failing to appear in court. That's what the change down in lines 28 and 29 of page 1 say. And then the back end of that is the final provision on the final page that says you're not suspended for failure to pay costs and fines any longer. And that's retroactive.
Thank you. Questions or discussion regarding the proposed amendment? Senator Gossage?
On this, Madam Chair, we go to Jason, I believe. Jason, then, is there any penalty for not paying fines?
Madam Chair, so it would still be considered failure to comply. So you're violating KSA 2110 by not paying your fines and court costs as ordered by the court if you adopt the bill. But you would not be suspended for that reason. So my recollection is that the court would still have, whatever authority it has over you as far as managing your payment plan, determining whether you've substantially complied, all of the other things in the bill, but they would not be suspending or restricting your license solely because you didn't pay. So it depends on how you view that, whether that is a punishment or or a consequence for not paying. But there is some oversight by the court. I guess I'll say that, and then maybe I'll leave it to the proponent of the amendment to kind of explain what she views as the consequence or the penalty if you don't.
Thank you. Senator Stefan has a question.
Thank you. Yeah, I would ask the carrier of the amendment to help me understand what the intention of the amendment is.
The intention is to decriminalize folks that are poor. So if you are unable to pay, the requirement is to pay all fines, all court costs, and all penalties as ordered by the court within 30 days from the date of the mailing notice. And what we have heard in testimony is not only in the state, that is that vicious circle that I believe Senator Faustido spoke to. How do you break that vicious circle? Now, what we have heard in proponent testimony for Senate Bill 500 is it's another tool in the toolbox. Well, if the tool in the toolbox is to continue to penalize folks that can't make the payment, don't understand the convoluted process, or I'll just give an example, in Eudora, that's the wrong town. In a community that I received a phone call about, not Eudora, but in a community they received a phone call about your court hearing, you're given a date and you're told to show up by 8:30 in the morning. Everyone that within a certain time frame is told to show up on that date at 8:30 in the morning, and you sign up on a clipboard, and you might be sitting there for 2, 3, 4, 5 hours waiting for your name to be called, only to be able to go up there and say, I don't have the funds to pay this off. So that isn't an appropriate process where folks that may have a job have to drive illegally to get there, can't afford the court costs, can't afford the fines and fees. And if they happen to have a job, they have to take the day off because they have no idea when their name will be called and what type of agreement might be shared by the court with them. So this is simply saying that we're not going to, it's revoking the authority to suspend the driving privileges due to non-payment. Thank you, Madam Chair.
Thank you. Senator Wilborn.
Thank you, Madam Chair. This proposed amendment is not supported by law enforcement. And matter of fact, they'll fall off on supporting it. The amendment that is pending that I proposed a moment ago, waiting on it, gives a ton more pathways to compliance, not full payment. So I'll be opposing this amendment. It appears to be a gut and go for 440.
Thank you. Senator Olson.
Thank you, Madam Chair. I'm going to support the amendment. I think we just got a lot of people struggling. I mean, I understand the Wilborn amendment, but it helps a lot of people too. But this one here really does. There's certain cities that they just run these people through, and some of these cities they won't even look at if you got the evidence to prove yourself innocent. They won't even look at it, knowing then you'll have to take a diversion or go to court. And I really applaud the senator for bringing this. I'm going to support it. I think the only thing I don't see in all these amendments that I wish was that this would go into the register.
Thank you, committee. Senator Baumgartner.
Thank you, Madam Chair. I certainly would support if he had an amendment for it to go into the register. Thank you, Madam Chair.
Committee, is there further discussion on this amendment? Senator Stefan.
Thank you. Yeah, I had the opportunity this weekend to speak to county prosecutors who are actually in those traffic courts and actually are a part of the process. And amongst the two that I had access to, they placed a lot of the blame of this thing on the fact that you have to have your license reinstated or cleared by the state. after you pay all their tickets, and that all these people, one of the prosecutors said 50% of the problem is that the people don't understand that they've got to get their license cleared through the state here in Topeka. The other prosecutor said it was 100% of the problem. And they both said that they actually getting the payment plan set up and getting all that taken care of was not an issue for these folks. So I'm pleased that we had an interim committee. I'm pleased that we're working on this, but I'm not convinced we've talked to all the right people, and I'm not convinced we have a clue on what we're doing here. So I don't support this. I think this goes back towards what I talked about the other day. It's a fine line between being a criminal and a victim, apparently. So I won't support this amendment. Thank you.
Thank you. Committee, other discussion on the amendment? Not seeing any. Natalie, did we get a second on the amendment? Second from Senator Olson. Committee, you all have heard the motion. Then all those in favor signify by saying aye. Those opposed, no. The chair is in doubt, so we're going to ask for division. And thank you, Lance. And so all those in favor of the proposed amendment, please signify by raising your hand. In favor of the amendment. Thank you. And all those opposed, please raise your hand. Okay. There is a tie, so I'll need to break the tie, and I will then say that based on the discussion and that law enforcement would not be in favor of the amendment, the chair votes no. And we are back on the bill, the amendment having failed. Yes, Senator Baumgardner.
Thank you, Madam Chair. I have one last amendment.
I think actually I'm going to call on Senator Wilborn if we have the copy of the amendment that we were waiting on for the back to arrive. So we're going to do that. Thank you. And yes, now that we have the full proposed amendment. Thank you to staff for providing that for us. And with that, then we all have our copies. Senator, would you like to explain or have the revisor?
I think it'd be best if we asked Mr. Thompson to brief us on this, please.
Thank you, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. All right, so now that you have the back page of this one, this is a new subsection that provides that any conviction for failure to comply under this section shall not be considered by the municipal or district court or the division of vehicles if that condition is greater than 5 years old in determining suspended or restricted driving privileges. So after 5 years from the date of conviction, the division notifies individuals that are suspended or restricted and whose driving privileges have not been restored. The division notifies the individual that they're eligible for driving privileges as a result of that expiration for failure to comply. And then that would trigger the normal sort of reinstatement processes. If you're not otherwise suspended or restricted, you might be able to get your driving privileges restored. So essentially, this is a 5-year look back is kind of a little colloquial way to think of it. After 5 years, you would be able to get your privileges back.
Thank you, Senator Wilborn.
Thank you, and thank you, Mr. Thompson, for explaining this. And this does have full support of law enforcement and the coalition of people that we've been working with, Justice Action Network in the Kansas Chamber. Thank you.
Thank you. Committee discussion or a second? Yes, Senator Baumgardner.
So a question for the carrier. So essentially, the individual that has a suspended or restricted driving privilege will drive illegally for 5 years before it's wiped away. Is that correct?
Mr. Thompson, could you answer that question? I don't think I understood the question. Could you,
Could you repeat the question, Senator Baumgartner?
Yes, with this amendment, that failure to comply. So if they have that suspended or restricted driving privileges, so essentially during those 5 years, if they were to drive, they would be driving illegally. Is that correct?
Madam Chair, Jason Thompson, I'm not sure I can just say yes to that. There would be a period of years where you could have restricted driving privileges and drive lawfully. And maybe I didn't make this very clear, but there's kind of two parts to this subsection. The first part is looking at what you consider a previous conviction. That's sort of the look back, which would go into whether you're eligible for certain restrictions and how many times you violated and that sort of thing. And the other part is sort of after your 5 years, you'd be notified that you might be eligible to have your privileges restored. So I can't say there wouldn't be a window where you might have no driving privileges. And so if you drive, you would be in violation of the law. But there's also a period where you could have access to restricted driving privileges using all the amendments that you've already adopted. I hope that answers the question.
Thank you, Senator Baumgartner.
So as a matter of clarification, you could go to the grocery store, you could go to the gas station, you could go to school, pick up your children. If there was a health emergency, you could do that, and you could participate in faith-based activities. But otherwise, if you were driving for vacation or to go see an athletic event or something like that, you more than likely would be in violation. Is that correct?
Mr. Thompson?
Madam Chair, I think I can say yes.
Thank you. Senator Baumgartner?
The only other follow-up question is, how exactly would the court notify this individual? Would they be using whatever was the address of the license at the time in which it was either suspended or restricted?
Mr. Thompson?
Madam Chair, the amendment just talks about the division making that notification. So the division would use whatever resources they have available. And I wouldn't know beyond that.
Thank you. Senator Wilborn, did you have your hand raised?
the only comment I would have along those lines was it doesn't change the notification process. This amendment doesn't address that.
Thank you. Committee, further discussion on the amendment. Senator Olson and then Senator Haley.
Thank you, Madam Chair.
And then Senator Steffen. Sorry.
So when would the clock, Jason, when would the clock start? I mean, and would it stop if there was a violation and then the clock get re-extended, or how would that work? I mean, would it start at the initial, or what if they do have a driving situation where they've failed to comply? Does the clock then start at that point, or where? I mean, I think this is kind of open-ended, leaving it up to when that clock starts too. And I think, you know, the Senator Baumgartner makes a great point. You're going to have people driving without a license. You've restricted them so much. That's my point.
Thank you. Mr. Thompson?
Madam Chair, so the language of the amendment is attempting to deal with the standard, the scenario where your failure to comply under this section triggers a suspension or restriction. 5 years from the date of that conviction, that's when the notification requirement kicks in for the division to tell you you may be eligible for driving privileges. The complications happen if you get another failure to comply. That would be a separate action with a separate 5-year clock. So the division might notify you, well, you're eligible from conviction 1, and you ask, and they say, no, you're actually not eligible because of conviction 2. Another scenario would be if you have anything else in your driving record that you've done other than that failure to comply, that might restrict you from getting your privileges back. But essentially, it's based off of the individual conviction under this section and the 5-year clock. And then all the other variables come into play depending on the person.
Thank you. Does the carrier of the amendment wish to reply, or I'll ask for other questions?
I have no further comments other than, again, this has been approved or supported by law enforcement and the coalition we work with.
Thank you. Senator Haley.
Thank you, Madam Chair. And my concern is kind of along what's been expressed with this and the previous amendment, the one that regrettably failed on a tie vote. Is the real world application of what this bill does. I mean, I think this committee did not have the benefit, as the interim has, of seeing real world applications for people whose licenses are suspended, because what will happen without some means to make them legal or give them the opportunity to drive legally is they continue to drive illegally. That's what happens. And this 5-year, or putting a 5-year and then it expires. And I guess my question that's in here is, if after 5 years, would then the notification require the suspended driver to make reapplication, like a driving test, or what, by which means would a reapplication for a driver's license take place after 5 years? Would it require completely going through the process again of the physical driving test along the other responsibilities, or what would that be with the trigger? I guess that question would be to Mr. Thompson, if there's anything that specifies what would be needed.
Thank you. Mr. Thompson?
Madam Chair, Jason Thompson, and I'll say again, Revisor's Office, not Division of Vehicles. So I'm struggling to find a specific answer here because that's not exactly my area of expertise. But I'm looking in the bill because I know there's a process under current law that talks about what happens when your suspension or restriction is up under this section, and that's what would apply. I don't know that it's actually in this section that's in the bill. Yeah, there's a triggering mechanism for the Division of Vehicles to initiate their restoration process. And I know that requires payment of a reinstatement fee. That's in the bill in this section. And I know it requires an application, essentially. Maybe that's not the right word the division would use, but it does require some effort on the part of the person who wants their privileges restored. I can't say whether it requires a test or anything else. I just don't know.
Thank you, Madam Chair. Thank you, Mr. Thompson, who, by the way, if you don't know already, committee and anyone else, whose acumen, Mr. Thompson's acumen on these and other issues is without equal during this process. So I greatly appreciate, as always, your insight. And why is there a difference from the opening of Section 1 of 3 years for the suspension or revocation, and this going to a 5-year? I mean, just the differential between the 3 and the 5 years. Is there any clarity that Mr. Thompson might help us better understand?
Senator Wilborn?
Brief response to the good senator from Wyandotte. It's 2 different sections, 2 different issues.
Thank you. Does that clear it up for you, Senator?
I just was wondering if 5 were an arbitrary number, because in previous incarnations of there was it was always 3. I didn't know where 5 came from, why that was considered a good, when 3 had been the standard in other sections. But thank you, Madam Chair, and thank you again, Mr. Thompson.
Thank you.
Senator Wilburn.
Did you want to reply, Senator Wilborn, or wait? Okay, thank you. Senator Steffen's been waiting for a question.
Thank you. And I think that my question partially got answered, but I would take some verification. when you read this amendment on page 6, when you read it in a bubble, as it is, it just talks about the passage of 5 years. There's no, it's not tied to good behavior or any of that. But it sounded to me like I heard that if you kept creating problems for yourself, that date would keep getting bumped down the road. Is that correct?
Is that a question for the reviser, Mr. Thompson? Mr. Thompson.
Madam Chair, Jason Thompson again. Yeah, so anytime you, and the language of the final sentence of the balloon is cautious for this reason, the individual may be eligible for driving privileges as a result of the expiration of 5 years. Because anytime you apply to the division or you're seeking your driving privileges, there could be any number of reasons you wouldn't get them restored. And this just allows the division to look at your driving record and make sure this was the only thing. It has now been 5 years. We can restore your privileges. But if there's anything else in your record, a DUI, another failure to comply, a violation of the restrictions under this section during your 3-year period, any of those might trigger a different response from the division that says we cannot restore your driving privileges. So the may in that final sentence is critical.
Thank you. Other questions on the amendment? Senator Baumgardner.
Thank you, Madam Chair. I'm just referring back to some testimony. And that is that one study found that about 75% of all drivers with suspended licenses continue to drive. So I am concerned. I appreciate this is an effort to erase, but I think 5 years is excessive. And, the interesting thing is when we look at, so that statistic of 75%, that is really more of a global, not limited to the state of Kansas. But when you drill down to the state of Kansas, the Department of Revenue reports that most suspended driver's licenses in the state of Kansas are unrelated to motor vehicle related offenses. Of all suspended licenses in the state, 84% are due to unpaid fines, fees, or court costs. So while I appreciate this effort to erase, it doesn't change the fact that for most individuals, the reason they would be driving illegally for 5 years or potentially outside of the restriction for 5 years is simply because their license was suspended because they couldn't pay the fines, the fees, or the court costs. And I want to remind the body that just 2 years ago, we had the 6th highest suspension rate in the country. So I'm not certain. I appreciate that this gives the potential for restitution, but I see that by making it 5 years, I understand why law enforcement might support this, because I don't think anyone or a few would be able to abide by it. I think that they're going to, if the data is true, 75% of all drivers with suspended licenses continue to drive, the likelihood that they would make it 5 years without any type of infraction seems very, very limited. Thank you, Madam Chair.
Thank you. Senator Wilborn.
Thank you, and I appreciate those remarks. Our First Amendment kind of took care of some of the suspensions and those fees. And our Second Amendment, as it relates to those non-traffic violations, should aid a lot in that regard also. There's no perfect formula here, but I do understand and appreciate Senator Baumgartner's remarks. Thank you.
Thank you. Committee, any further discussion? And yep, Senator Gossage.
Thank you, Madam Chair. I'll make this very quick. So this is for you, Jason. we talked about a payment plan. If someone is participating in a payment plan, maybe their fine is $200 and they're paying $10 a month or $20 a month, and then they get caught for driving, not to any of these locations that we mentioned. Are they given additional fine, or are they allowed to drive as long as they're participating in their payment plan? Could you explain how that works?
Mr. Thompson?
Madam Chair, Jason Thompson again. So I'm looking at the restricted license privileges that are both on page 2 and then on to page 3 and then on page 3 at the bottom. So the two different license restrictions that are here, both of them contain the provision. There's one on the top of page 3 on line 10, and there's one on the bottom of page 3 on line 40. If you're operating your vehicle in violation of the restrictions imposed on you by this section, you are operating a vehicle in violation of restrictions as provided in KSA 8-291, and that is a violation of the traffic code, and that would trigger some sort of penalty that I need to look up again because it's been a week. That is a separate misdemeanor. It is a fine, and it is an additional potential suspension of your privileges for 30 days to 2 years for a first offense, and then 90 days to 2 years for a second or subsequent offense. So essentially, it is a separate violation if you violate your restricted privileges. So if you did that and got caught, you'd have another thing on your driving record you'd have to deal with.
So if I may, then if you're driving with a restricted license and you go outside of the parameters, that is a violation, but it would not be a violation for not paying a fine because you are staying within the payment plan. Those are two separate violations. Am I understanding that correctly? As long as you're staying within your payment plan, you're not going to have a violation for not paying.
Madam Chair, Jason Thompson again. Yes, so if you're making your payments, that is one issue. If you're violating your restrictions, that is a separate violation that has its own penalties. They are two different issues, yes.
Thank you. Thank you, Madam Chair.
Thank you, committee. Any further questions on the amendment? And Natalie, Senator Corson.
Yeah, thank you, Madam Chair. I'm supportive of this amendment because I think whatever other misgivings folks may have about different parts of the bill or other parts of the bill, I think this amendment in and of itself is a positive amendment. I think it moves the bill in a better direction, even if it's, a small step forward. I still think having this 5-year look back is positive, and I would rather have it on the bill than not. Again, even if I know there are other parts of the bill that not everybody may be in love with, but I think the amendment in and of itself is positive, and I'm going to be supporting it for that reason.
Thank you. Any further discussion or questions on the motion? And Natalie, do we have a second on the motion or on the amendment? We do not. Is there a second on the amendment? Well, Senator Corson with the second. You all then have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. And with that, then we are back on the bill. And Senator Olson will be recorded as a no. And so will Senator Haley. And so will Senator Baumgartner. Thank you. Committee, we are then on the back on the bill. Senator Baumgartner.
Thank you, Madam Chair. I have one more amendment.
Does the staff have it to pass it out? Thank you. Thank you.
Front and back. Mhm. I've seen it.
Thank you. Senator, would you like to explain your amendment or have the reviser?
Oh, I think the reviser could probably explain it better than I can, but simply what it does is it addresses the issue of inconsistency statewide, and it provides for hardship payment plans and a waiver of fines. And when you turn to page 5, it lays out, so there's no guesswork. It lays out the monthly payment plan amount shall be the greater of either $10 or 2% of the person's annual net income. That is divided by 12. We might need to have, it might be that that person might not have a recent tax return. So I guess if there was a friendly amendment to say a pay stub. But the other thing is it also allows for the court can enter into the aspect of performing community services and attending classes, either online or in person, and that credit, once they have completed the hours of service or completed those courses, that balance would go toward what they owe. So I will stop at that and let the reviser pick up any of the fine details that I did not address.
Mr. Thompson, if there's any other additional or if you want to wait for any questions, go ahead, Mr. Thompson.
Madam Chair, Jason Thompson, I'll just say quickly, there's 3 pieces. The first is the $10 or 2%. The second is the credit based off classes or community service at the rate of $15 an hour. And then the third is the waiver application that has to be made available for everyone to use. That's the amendment.
Thank you. Questions or discussion on the amendment? Senator Wilborn.
Thank you, Madam Chair. While I appreciate again this amendment, basically the underlying bill does that with giving judges discretion. This does lay it out a more specific plan, but the ability to build a pay plan is in the bill as we speak.
Thank you. Committee, further discussion on the amendments. Senator Corson.
Thank you, Madam Chair. I supported Senator Baumgartner's previous amendment, and I'm supporting this amendment for the reason that I think we need to be data-driven in this committee. And if you look at the data is overwhelming that folks who have the ability to pay, they do pay. So these are not folks, it's not the case that folks who have the ability to pay are just refusing to pay. This is truly a population of folks who is unable to pay. They're unable to meet their basic needs and they're unable to pay. And I think this provides in a more detailed, thoughtful way an ability for them to get right with the court. And so I'm supporting this. I supported the previous amendment for the same reason. And I think that this hopefully will get on the bill. Thank you.
Thank you. Senator Wilborn.
Thank you, Madam Chair. I'm going to ask the reviser if he can specifically explain how this ties in with the bill, underlying bill, and is there any conflicts with it or overlap? Thank you.
Madam Chair, Jason Thompson. So I attempted to make sure there was no direct conflict between these provisions. If I understand it correctly, even with everything else that's been adopted, although I'll have to look at it again now that it's changed a little bit, the court would be able to establish whether or not someone is substantially complying. They'd be looking at payment plans. And if they were doing all of that, this would be a specific direction about how that plan should be structured. Things they should consider, amounts they should charge. And the waiver application itself obviously does not conflict in any way. That's just an extra piece that could be added. So I think it all works together as just a direction for the court based off of what the bill and the amendments say the court could do now. This just gives them more specific direction.
Thank you.
Thank you. Senator Olson.
Thank you, Madam Chair. I'm going to support the amendment. I think it's a better way of making it more fair across the board, across the state, being applied this really does help them people at the bottom. So I'm going to support it.
Thank
And I
you.
second the motion if it doesn't have a second.
Thank you, Senator. Committee, other discussion or questions on the amendment? Seeing none, then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. Is there, Olson seconded it, yes. Yes, he did. Yes, Senator Olson.
If it's allowed, I'd make a conceptual motion to change this from the statute book to the register.
Before we entertain another amendment, I had one on the last amendment that passed, and I meant to make a conceptual amendment. There's a typo in it on page 1 of the amendment regarding hardship payment plans, and we need an I in the word waiver on the first page. Can we just correct that? And oh, she seconds that. So yeah. Okay, it's not a real word, so they'll fix that to put the I in. And then with that, sorry, Senator Olson, and the proposed conceptual amendment was to make it effective upon its publication in the register.
That's correct.
Just a moment. Generally, we don't permit conceptual amendments in committee. This is a relatively standard amendment that's made to a lot of bills. It's not hard to understand. It's not a lot of word changes. So the amendment is in order and there is a second. Is there discussion on the amendment? So we are on the conceptual amendment from Senator Olson to amend section 4 of the bill on page 6 to change it from "this act shall take effect and be in force from and after its publication in the statute book" to be in force from and after its publication in the register. Do I have that right, Senator Olson?
You do, and I just think this would be a good amendment to get it on the books as quick as possible. And I think it also gives you a good position in conference if that's where it goes.
Thank you. This is not a bill that's come over from the House, so it's a Senate bill. But tell me about. I'd like some discussion if we have any thoughts on this. Is a pretty complicated concept that we're proposing here, and a lot of changes for our law enforcement, for our courts, and is it something that could be implemented as quickly as has been suggested by the amendment? So just some thoughts about that or any discussion on that would be my concern. Not hearing any then. So my concern would be, would our agencies, would our prosecutors, would our courts, would our law enforcement be able to be up and running and to be in compliance if it's effective that quickly? So, yes, Senator Olson.
My guess, they've all pretty much got technology, and I think it probably could be up and running real quick if it passes. And if nothing else, they can straighten out anything that isn't. I think if this is good for the people, July 1st, it'd be good for the people even earlier than that of Kansas. So I'm going to support my amendment. Thank you.
Thank you, Senator. Any other discussion on the amendment? Not seeing any, then you all. Oh, Senator Wilborn.
Yes, Madam Chair, I make a motion to move Senate Bill, 500 as amended out favorably for passage.
Madam Chair,
that motion is not yet in order because we have a motion on the table to conceptually amend the bill to its effect upon register.
I
in
apologize.
the-
I thought that was a done deal.
Oh, sorry. We haven't voted yet, Senator. So with that, then, no further discussion. You all have heard the conceptual amendment. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. Senator Olson, I think you have a motion. I'm sorry, Senator Wilborn, I think you have a motion. Thank you.
It's getting late, obviously. Thank you, Madam Chairman. I would like to move Senate Bill 500 as amended out favorably for passage.
Committee, is there a second? Second from Senator Olson. Is there any discussion on the motion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. Committee, thank you for your work on that bill. We will next turn to Senate Bill 491. And Senate Bill 491, as you'll recall, it's 211 pages. We heard it yesterday. And I don't have the short title in front of me, so I will leave that. Thank you. Concerning criminal history and record checks relating to the Kansas Bureau of Investigation standardizing fingerprinting requirements and making conforming amendments across statutes that authorize fingerprinting. So with that then, a brief from the revisor.
Thank you, Madam Chair. Jason Thompson, Revisor's Office, yet again. Senate Bill 491 is to standardize criminal history record checks regarding fingerprinting and to define who is fingerprinted on those checks. There's 3 new sections. One is for the criminal justice agencies. Number 2 is for the non-criminal justice agencies. And number 3 is for the folks who get a name-based record check. I'm confirming that before I move on. Yes, name-based record checks for certain individuals. And then, as I mentioned yesterday, and the KBI mentioned, sections 4 through 103 just makes a lot of changes related to the changes that are made in sections 1 through 3, so that anytime you're allowed to gather fingerprints and submit them for a criminal history record check, your statute will direct you to the appropriate place in section 1, 2, or 3 for how you do that process, and it would be standardized across all agencies in the state.
Thank you. Committee, we're going to add to committee documents. There was a list of the agencies that would be impacted by this bill. We don't have a copy of that. Could we get a copy of that? Real quickly passed out. I'm just going to highlight a few of them, of the agencies that are impacted. The bank commissioner, the board of nursing, the governor, the insurance commissioner, the Supreme Court, the attorney general, Department for Aging and Disability Services, Commission on Veterans Affairs, Commission on Peace Officers Standard and Training. So those are some of the commissions or divisions. Legislative Division of Post Audit would be impacted as well. So we will add those to the committee documents for your reference. And with that then, are there any questions for the revisor? Not seeing any. Is there discussion or a motion on the bill? Committee, I do have an amendment on this bill, and it's a bill to help clean up some technical changes and make sure that we have all the agencies in the right part of the statute and under the right subsections so that they can do the work that they need. It is an amendment brought to us by the Kansas Bureau of Investigation. And now that you have the amendment, I will ask the reviser to explain.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. This is the amendment that we discussed yesterday in the hearing and have worked on for the last 24 hours or so. There's quite a few little things that you might think could happen in a bill of this size, despite the numerous eyes of attorneys and practitioners that are on it. I'll just kind of walk through each change as briefly as I can. I just want you to understand what they do. On page 3, you see the first strike, and that is removing the Attorney General related to KSA 757B01. That is private detectives. It is removed from this section, this subsection, and it is placed down below on the top of page 4. So it moves from subsection B to capital C down to B4 capital C. And the effect of that is that rather than getting, the effect of that is that the Attorney General would continue to receive the information listed in B4. Adult convictions, adult non-convictions, adult diversions, and adult expunged records. In working with the KBI, that is what they receive now. Moving them from B2 to B4 would preserve what they currently receive and not make a policy change. So that was the goal of that amendment. The next one, so we've covered page 3 and then on top of page 4. So the next one is on page 4, you see the insertion in line 17. That's the EMS board. So this is the one they discussed in their testimony yesterday. And they would be moved from page 5, where they are in subsection B7, capital F. So you'll see stricken language on page 5. And they are moved up here to subsection B5. And they would continue to receive adult convictions, adult non-convictions, adult diversions, and juvenile adjudications, just as they do now. And some of that information is not included in the lower subsection. So they needed to be moved up here to preserve that. There was discussion about a potential policy change that they requested, and I will say this is not that policy change. That is a separate issue that you might or might not take up. This just preserves what they currently receive. Then the next change on the top of page 5, you'll see I started doing some cleanup. We sometimes used the singular applicant or licensee. Most of them use the plural, so we're going to use the plural. And so you'll see that change a few times. That's a technical cleanup thing that our office decided to do while we were in here. But on the top of page 5 in line 3, you'll see there's an error. KSA 65-28, 102 should be 65-2802. Obviously, that's an error of law and would need to be corrected, so we're taking this opportunity to do that. The next one of substance is at the bottom of page 5. You see the big box that's added would add new subsections, subparagraphs, capital M and capital N, related to the insurance commissioner. This was requested in their testimony before the committee. This moves them to subsection B8, where they get adult conviction. Up to subsection B7, where they get adult convictions and non-convictions. And they get just that, adult convictions and adult non-convictions. And they are moved here from the previous page, from page 6. So you'll see it was struck, or the next page, struck from page 6 and moved up to page 5. Again, preserving what they get under current law, not a policy change is the intent. I think that covers everything in those sections other than the changes to the plural, licensees, applicants, etc. And then the final change of note here in the first couple sections is the strike on page 7. That subparagraph X is duplicative of one up above. So that provision is in the bill. It's in B7 capital K. So if you see the one in B7 capital K, that one is preserved. B8 capital X is removed. There's no need for two provisions in the bill. It's just an oversight. The next change, and hopefully in the copies you got, I cut out all the pages that didn't really have any changes because I didn't need to print 200. Page 9, there's a couple just technical cleanups. It doesn't change any of the substance. Page 19 is the next one of substance. This was brought to the attention of the KBI and our office by the Supreme Court. This statute uses the phrase "the clerk of the Supreme Court" in 5 places, and it should just say the Supreme Court. So that's what that one does. That's to clean up the court's statute related to fingerprinting of folks like me who apply to practice law. So then the next page that's in your amendment is page 67. I kept it because this is the beginning of the statute for the insurance commissioner, but the change doesn't happen until page 69. This reinserts some language that you see there on lines 14 through 16 that was stricken inadvertently that allows the commissioner to charge the costs to the applicant. So they asked for that in their testimony. Again, not trying to change the current law, mistakenly struck that, putting it back in at the request of the insurance commissioner. Same thing for them on page 72. Inadvertently struck a cost provision and would be reinserting that. The last couple here are dealing with the Board of Pharmacy. I left in page 110 because that definition of fingerprint candidate that's new in the bill on line 2 is the definition that we should reference on page 116. The term used there was licensee. The board gave you testimony saying that was not broad enough. The term defined is fingerprint candidate, so we just put that term in instead. Should solve the problem for them and be accurate with what's in the bill. The final couple of changes relate to the Attorney General. There's on page 193 in the private detective statute, page 197 in the bail bonds, bail enforcement agent statute, and page 191. I'm sorry, I skipped that one. I flipped my pages over. Page 191 related to private detectives, page 193 related to private detectives, and page 198 related to bail enforcement agents. Those 3 would attempt to make the language clearer that they collect the fingerprints and submit them to the KBI for a state and national criminal history record check. That's more standard language used in the bill. And you'll see their language was a little more general about any criminal history. And part of that was causing confusion about which subsection they should be under up above. So this just makes that clearer and uses the consistent term. I think that covers all of them. So again, fairly technical, trying to preserve current law, but got a little bit lengthy.
Thank you. When you say private detective, could you define what that means?
Sure, Madam Chair. That's one of the sections in the bill. So under KSA 75-7B 01 et sec, the Attorney General licenses private detectives, and as part of that, they do fingerprinting and background checks, so that's why they're in the bill. They are defined as, just trying to get to the right page here.
And these are private detectives who work on their own, not necessarily in conjunction with law enforcement.
Correct. So in 75-7B01, which is in the bill, because we define applicant for purposes of that. So on page 189, that statute begins. And then on page 190, the definition of private detective is someone who engages in detective business. And detective business is defined in that statute as furnishing of, making of, or agreeing to make investigation for the purpose of obtaining information with reference to crimes or wrongs, identity habits, and other things of another person. Essentially what you would think of as engaging as a private detective, which is not the same as law enforcement. It is a separate license, yeah.
Thank you. Committee, other questions for the revisor? Not seeing any, then is there discussion on the amendment or a second on the motion to amend? Yes, Senator Gossage.
I will second the motion.
Thank you. You all have heard the motion. Any further discussion? Seeing none, then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill and want to advise committee that the list of agency, office, board, or commissions that are impacted by Senate Bill 491 has been distributed to committee members, and you can see those in front of you. With that, then, is there further discussion or a motion on the bill as amended?
No, oh yeah, what's that on? She says, I think she, I'm just trying to find.
And committee, while we're standing at ease, thank you for standing at ease. I was going to make an announcement, but I don't have one. Thank you. And with that, then, Senator Gossage.
You may remember that the emergency medical services were here. And so we've addressed some of the concerns from the pharmacy and from the Department of Insurance. This is a request from EMS. And so it's just a very
Wait a
simple
minute. Are you
amendment.
going to make the amendment? We'll need to have it distributed.
Yes.
Thank you.
I'm sorry. I thought he'd already done that. I
Okay.
apologize. Just to me. I know we have people that need to go. This is very, very quick. I promise.
Go ahead.
I'll have Jason explain it when he gets back.
Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. So this is the one discussed by EMS. And as I mentioned in the last balloon, you moved them from subsection B7, I think it's to B5, so they get the information they're getting under current law. But in their testimony, they asked you to actually start getting additional information, which would require moving them to B3. That's what this balloon would do. And as I had mentioned a few times in my brief, and as the KBI mentioned in their testimony yesterday, what we tried to do was preserve whatever access you're getting under current law and just standardize it. So any policy choice about additional information you would receive, we've tried to give that to you separately, and this is one of those. They would, if moved to B3, receive adult convictions, adult non-convictions, adult diversions, adult expunged records, juvenile adjudications, juvenile non-adjudications, and juvenile diversions. So they'd receive essentially everything in your criminal history practically. Down in B5, they don't get quite that much. They get, in B5, you get adult convictions, adult non-convictions, adult diversions, and juvenile adjudications. So not the expunged issues, not the juvenile non-convictions, right? So again, policy choice, they gave you some testimony about why they feel they need that additional information, and this would be the balloon that would do it.
Thank you. Committee, any discussion?
I should say, if you adopt this balloon, it would replace the similar balloon that was made, right? So if you adopt this one, I would just put this change in the other one instead of moving them to B5, I'd move them to B7, so we can make them work together if you adopt this one.
Thank you. Committee, any discussion or a second? Do we have a second? I'm not seeing a second. So second from Senator Baumgartner. Any discussion? Seeing none, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill as amended. Any further discussion or a motion? Senator Haley.
Just to clarify, and I think I already know the answer, this is all prospective, is not retroactive, that if implemented, this will be going forth from the publication in the register for future applicants, not for any current employees.
Could you clarify, Mr. Thompson?
Madam Chair, there is nothing in any of the substantive provisions that indicate that you would go back and fingerprint anyone who wasn't already fingerprinted, or that you would do anything retroactive. This would just be anytime you do take fingerprints and submit them to the KBI, this would be the way that the system is supposed to work going forward. So I don't see anything retroactive in it, no.
Thank you, Madam Chair.
Thank you. Committee, any further discussion or a motion on the bill as amended? Is Senator Gossage?
I move we pass Senate Bill 491 out of committee favorably for passage.
As amended, correct?
As amended.
Thank you. Committee, is there a second? Senator Bowers, thank you. Committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. And we have one final bill, shouldn't take long, famous fast last words. Senate Bill 473 brought to us by law enforcement regarding a change in the notice to appear. And it's an agreement, I understand, between the prosecutors and law enforcement. And if we could have just a brief, short brief on it to remind committee. Thank you.
Thank you, Madam Chair. Jason Thompson, hopefully for the final time. I'm getting a little tired. I'm just kidding. I'm earning my pay today, earning my pay. So this is the bill that authorizes a notice appear that meets certain requirements to serve as a lawful complaint. This is the Code of Criminal Procedure, so the foundation for charging someone with a crime. You can issue a notice to appear, which has certain information in it. If you adopt the bill, that notice to appear would have to contain all of the information required by the Code of Criminal Procedure, and there would have to be a memorandum of agreement between the agency issuing the notice to appear and the county or district attorney in that jurisdiction that says that notice to appear document is deemed a valid complaint. And so when that is submitted, it is a complaint that charges you with a crime. So it essentially, one document takes the place of another document and works for that purpose under the Code of Criminal Procedure. But again, it requires a memorandum of agreement, and it requires a number of items to be on the notice to appear in order for that to work.
Thank you. Committee, any questions? Seeing none, any discussion or a motion? Senator Olson.
Quick question on the notice appear. So what if it's a traffic violation, but they notice you to appear? I mean, these cops sometimes are doing that now my way, where they're making people appear. I don't know. To me, you know, you ought to be able, I don't know, be able to hire counsel or something and not have to appear. I don't get that, but I mean, I don't know. Maybe I'm confused.
Thank you, Mr. Thompson.
So, Madam Chair, Jason Thompson again. If I understand right, I think I can answer this by saying it doesn't change anything about whether you have to appear or the way the Code of Criminal Procedure works. Essentially, it's just saying the notice to appear that's issued to you, if it contains the right information and there's a memorandum of agreement between the local prosecutor and that agency that employs that officer, and it's signed by the officer. I kind of forgot that requirement, but that's needed as well. Then when they submit that to the court, that document can be deemed the complaint that triggers the criminal prosecution of you. But then that triggers all of your constitutional rights and all of the other Code of Criminal Procedure that would apply. You did mention a traffic citation specifically, so I wanted to be clear. This is current law. This is allowed for a notice to appear that complies with KSA 8-2106, so that's like a traffic citation, or a notice under 32-1049, which is a wildlife and parks citation. So the current law that you find in the bill, it's at the top of page 2. If you issue a citation or a notice to appear that's in compliance with those statutes, it is deemed a complaint under current law. What this one is doing is saying if it's in compliance with the criminal procedure code, and you have that memorandum of agreement, it can serve similarly as a complaint. So I didn't want to mix up traffic and wildlife and parks and a true like criminal charge. While traffic citations or traffic infractions are crimes, they're a subset of crimes. They're handled a little bit differently. So big picture, it doesn't change anything about what's going on, and smaller picture maybe, or directly to your question, I don't think it changes anything about traffic citations in particular, because this is already kind of happening with traffic citations.
Thank you. And Mr. Thompson, can you help refresh what happened at the hearing? Did we hear from law enforcement that this would provide some efficiency? Because if there's this memorandum of understanding, then the officer could issue the notice to appear rather than having to take the person who's been issued the citation to jail. And then the police officer would be able to be engaged in other crime fighting activities. I think there was some testimony in that regard.
Madam Chair, Jason Thompson, and I was conferring with research because they have really good notes about what happened in committee that will be reproduced in the sub notes that you'll see later. So kudos to them. Yes, you had testimony from Greg Smith, the Special Deputy Sheriff for Government, Veteran, and Crime Victims Affairs with the Johnson County Sheriff's Office, and from Ed Klump, the liaison for the 3 law enforcement agencies, the sheriffs, the peace officers, and the chiefs of police. And both of them talk about how this would expedite processes and save time for officers and potentially save having to take someone into custody and take them to jail. This would be something that they were in favor of. Yes.
Thank you. Senator Steffen has a question.
Not so much a question as a comment. You know, I found this interesting. It seemed to be that folks were asking to move down to a lower crossbar. And in the meantime, you know, they're diminishing the significance of some of these crimes like possession of drugs and shoplifting. And they, if I remember correctly, they compared it to the municipalities, the cities, and they wanted to be more like them. I'm not sure I want them to be more like them. I think we've seen some of our cities go the wrong direction in regards to how they deal with criminal activity. And I'm not a big fan of a bill that's more about convenience and ease than it is keeping the public safe. So I won't be supporting this bill.
Thank you. Senator Corson.
Thank you, Madam Chair. I would sort of respectfully disagree with that. I think this is a really good bill that we've got before us, and I think it's one that's deserving of our support because right now you have this kind of anomalous situation where a person could commit the same criminal act, and it really depends on whom you're stopped by or what law enforcement you have an interaction with. So you could do the same criminal act by a city officer and you're cited and released. But if you do that same criminal act and you're contacted by a county or a state officer, then you have to be taken to jail. So it has nothing to do with harder on crime or softer on crime. We're talking about the same criminal act, and just having that inconsistency, I don't think we're well served by that. And I think that's why law enforcement, county and district attorneys all support this bill. And also, if you think about the time that it's actually taking law enforcement officers off the street and away from either responding to urgent calls or just doing their general patrols to keep us all safe, because they're having to spend a lot of time transporting folks to the jail, processing them, and then those folks overwhelmingly are allowed to sign out on their own recognizance. So I think this is actually a bill that will reduce crime and is supportive of law enforcement. And that's why I'm supporting it.
Thank you. Committee, other discussion. Senator Steffen.
Thank you. The concept that we were going to reduce crime with this bill escapes me. shoplifting. We have a huge problem with shoplifting. You think we're going to encourage people not to shoplift by writing them a ticket and sending them on their way? No, not even close. Again, this gets down to where you want to land on crime. And again, convenience is never an excuse to lower your efforts. And the end result is we are being soft on crime with this bill. You can try to explain it any way you want. But when you take a shoplifter or somebody in possession of drugs and you just hand them a ticket, that in and of itself minimizes the importance of the crime. End of story. It's that simple. Thank you.
Thank you. Mr. Thompson, would this be up to the discretion of the officer who has contacted the person about whether to issue the notice to appear or take them into custody?
Madam Chair, Jason Thompson. So that doesn't seem like a difficult question, but it kind of is. I want to start just by saying one thing that I forgot to say earlier. This is only for unclassified misdemeanors and non-person misdemeanors. So shoplifting we were talking about, that's a good one to talk about. But it doesn't apply to any felonies or anything like that. I neglected to mention that earlier, and that's fairly important. So the bill says a notice to appear issued pursuant to and in compliance with 22-2408, which is section 2 of the bill. And that is the statute that is not changed here in terms of when a law enforcement officer detains any person without a warrant for a misdemeanor and they're not immediately taken before a magistrate for further proceedings, the officer may serve upon such a person a written notice to appear in court. So it seems like, and I'm remembering my criminal procedure correctly here, the officer either has to choose to take you before the magistrate or they have to issue you a notice to appear. But it is may.
Thank you. Senator Olson.
Thank you, Madam Chair. I think if you remember right, our former colleague, Deputy Smith, and trust me, he's definitely very conservative, but he stated the sheriff's department there, when they pull someone over for these minor infractions, they have to take them to jail and they almost immediately bond out. And, this time would be saved because the city, like Olathe, Overland Park, the city law enforcement, if they had the same infractions, they would give them a notice to appear. So this would put the sheriff's department on the same level as the city police when they have these minor infractions, that they would then be able to just give them a notice to appear and they would appear in court. They're mandated to appear. Instead of taking them to jail, spending the time to book them, and then they immediately get out on their own recognizance. It's a save of time, money, and effort. I think I support this bill. I think it's a good bill. More I'm remembering the testimony. So thank you.
Thank you, committee. Any further discussion? Is there a motion? Senator Corson.
Thank you, Madam Chair. I would move that the committee pass out Senate Bill 473 favorably for passage.
Second from Senator Olson. Any further discussion? You all then have heard the motion. Those in favor signify by saying aye. Those opposed, no. The chair is unclear. Could we, I didn't hear. Okay, thank you. So, and Senator Steffen would like to be a recorded no. Thank you then, committee, for your attention today. And I want to clear up one thing. Today was the last day for us to hear or work non-exempt Senate bills. So with that then, thank you committee and staff, and the meeting is adjourned.